Well, the verdict in that case reaches past Kenosha, Wisconsin.
The case is fueling the national debate over guns and race relations. And joining us live now with legal insight is criminal defense attorney Alexandra Kazarian. Welcome, Alexandra.
Thank you, Pat.
From a legal standpoint, was the full acquittal surprising to you or not?
You know, it really wasn't. Kenosha is an open carry location, and the jury really had to decide, did he bring a gun there for the sole purpose of murder, for killing somebody? And at the time that he pulled that trigger, was he actually in fear for his life? And the standard that they would have to use is the standard of a 17-year-old person in that situation. It's a reasonable person in that situation, but it is specific to him. And so knowing that it's an open carry state, even though, you may argue that he had no business being there. He didn't need to be there. He crossed state lines. He had nothing to do with it. But they allow people in general to open carry. There are situations where that's allowed. So it makes it a little less nefarious that he went there with that gun. And knowing that, the situation is, would an 18 or 17-year-old who got himself into that situation, is it reasonable to believe that he's over his head, he's scared, and is it a reasonable reaction for someone in that situation to pull that trigger? So I do think that the jury had a lot to work with if they were willing to give that not guilty verdict. So I wasn't really shocked, and I definitely wasn't shocked that it came in the afternoon on a Friday right before a holiday week.
Yeah, there's a lot of things that are kind of different about this trial because it was in the state of Wisconsin. So let's kind of focus on the jury. Rittenhouse was allowed to do a jury raffle and pick the names of his jurors. One, how common is that, and is this kind of exclusive to Wisconsin?
No, the jury raffle actually is not. It is very common. It's not so common for the judge to allow the defendant himself to pick, but it's still a blind pick. Usually maybe a defense attorney will pick one and a prosecutor will pick one, or the judge themselves will pick all of them. But that procedure itself is not shocking, not weird. But maybe having him actually be the one to pull it was a little bit strange.
Well, Alexandra, the judge in this trial barred prosecutors from using the word victim. So is this typical in a courtroom with a case like this?
So, actually in California, there is a state bar recommendation that witnesses not be called victims throughout the pendency of the case, and that the prosecutor should not call any witness a victim until closing argument, after all of the evidence has been given to the jury. And that's because of the burden of proof and the presumption of innocence. If you think about it, if you had a loved one that was in trial and they were defending themselves and they were saying, look, these people that are testifying against me are not telling the truth, but the judge and the prosecutor and everyone in the courtroom was already calling them victims, it wouldn't seem right. You would ask yourself, where is this presumption of innocence? If the person that's on the stand, that's on trial, is innocent, why are we already presupposing that these people are victims? So it's something that defense attorneys ask for in every single case, but it's not given. It's not often that a judge will allow that, even though California state bar rules do recommend that witnesses not be called victims until closing argument.
Alexandra, of course, this really centered around self-defense. Will this verdict have any impact on future self-defense cases? This obviously was in Wisconsin, but maybe nationally as well?
Well, it went exactly the way a self-defense case would go. And, there's some question about why he testified or would he testify. In a self-defense case, a defendant most of the time always has to testify, because in order to get those jury instructions, a defendant has to get on the stand and they have to tell the jury that they were in fear. If the record is silent as to the fear that the defendant was feeling at the time, if they don't make a statement, if nobody knows from their own words what was happening inside of their head, they can't get that jury instruction. So oftentimes, a defendant has to take the stand, and obviously you're going to show some emotion when you're in this situation. And so I think there is no typical case. There's no typical murder trial. But I wasn't shocked by the way that things happened. I wasn't surprised that he took the stand. And I definitely wasn't surprised that he showed emotion, especially since he was so young.
Yeah.
But it's as typical, I think, as it could get for a 17-year-old to be charged with murder in this kind of a situation.
All right, Alexandra Kazarian, always a pleasure to have you on with us and get your insights. Thank you
Thank
so
you so
much.
much.